Good morning, everyone. My name is Samit, and I will be introducing our presentation today. Our group will be analyzing a complex contract law problem involving Rizal, a successful dealer in heavy construction machinery, who became involved in two problematic transactions that raised serious concern about the validity of his consent. In the first transaction, Rizal sold to Kamatsu excavator to a man named Razak after receiving a disturbing video in which Razak threatened harm against Rizal's daughter. This situation gave rise to the issue of duress, as we must consider whether Rizal's consent was fully uh, voluntary and whether he can recover the excavator from Ghazali, a third party who later purchased them at a price far below market value. In the second transaction, Rizal signed a bank guarantee on behalf of his solicitor and close friend Karim after facing persistent emotional pressure and persuasion. This introduced the issue of undue influence and raised the question of whether the guarantee is legally binding on Rizal or whether it can be set aside due to improper influence. Throughout this presentation, we will examine both transactions under Malaysian law, particularly the Contract Act 1950, and compare these principles with the position under English common law. The key law questions we aim to address are: did Rizal provide free and genuine consent, or was his will overborne by threats or influence? And as a result, can he recover his property and avoid the contractual obligations? Uh, with the overview, I will now hand over to Iman, who will begin to discuss the first transaction and the concept of duress under Malaysian law.
Good morning, everyone. My name is Iman, and I'll be discussing the first of Mr. Rizal's problematic transactions, focusing on the issue of duress under English law and coercion under Malaysian law. In the first transaction, Mr. Rizal, a dealer in heavy construction machinery, was approached by Mr. Razak, a recognized fixer known for using intimidation to win contracts. Razak sent an email demanding two Komatsu excavators for 10,000 each, despite each machine having a market value around 500,000. He attached a video on which he told Mr. Rizal's daughter, "If your father doesn't give me what I want, that pretty face of yours won't stay pretty for long." Mr. Rizal showed his daughter the video. She confirmed she had been threatened. Fearing for her safety, he delivered the two excavators the next day. A week later, Razak sold them for 100,000 total. The highlights of the following facts are: a threat of personal safety, urgent demand, wildly undervalued consideration, and delivery under clear pressure. In the English contract law, the relevant doctrine is what we call duress to the person. This arises when one party's consent is obtained by threats of violence or bodily harm. In the landmark case Barton versus Armstrong, the Privy Council held that where threat to kill was made, the contract entered into under that threat was voidable, even if the threat was not the dominant cause of entering the contract. Under English law, therefore, threat of physical harm can make the contract voidable. Under Malaysia, the comparable doctrine is coercion under Section 15 of the Contracts Act 1950. Section 15 defines coercion as the committing or threatening to commit any act forbidden by the penal code or the unlawful detaining or threatening to detain any property to the prejudice of any person, within the intention of causing any person to enter into an agreement. Under Section 14, consent is not free if caused by coercion, and under Section 19, contract is voidable at the option to the party whose consent was sought. The leading case is the Sarmal son of Lachman Das versus Waliappa Chettiar, where a property transfer made under the orders of the Sultan in the presence of Japanese officers during the Japanese occupation was held to be voidable because the consent was not freely given. Unlike English law's broader duress doctrine, including economic duress, the Malaysian notion of coercion is more narrowly drawn around threats or acts of a penal nature or unlawful detention of property. In both jurisdictions, the key consequence is that a contract entered into under threats of personal safety or threats of bodily harm is voidable, meaning the coerced party can elect to rescind or avoid it. Under English law, it is duress to person. Under Malaysian law, coercion under Section 15. Because pre-consent is lacking when a person acts under fear for safety, personal safety, the law treats the agreement as subject to set aside. That completes our discussion of the first transaction under duress coercion. Now, I'll hand over to Daniel, who will apply these principles directly to the situation between Rizal and Razak. Thank you.
Thank you, Matt, for the clear breakdown and legal principles of duress and coercion. Now, let's take those principles and apply them directly to Rizal's concerning situation with Razak. We will need to answer the critical question: what can Rizal actually do about it? We will be looking at his remedies and then tackle his tricky situation with the third party, namely Ghazali. So, let's dive into the application. First, let's establish that Razak's action undoubtedly amount to coercion under Malaysian law and duress under English law. Razak's email contained a clear threat. He stated, "Before you turn me down, watch the video attached." This video itself showed a direct threat of violence against Rizal's daughter. This is a classic example of a threat to a family member's safety. Next, threatening physical harm is an absolute and act forbidden by the Penal Code, satisfying the definition of coercion under Section 15 of the Malaysian Contracts Act 1950. Under English law, this is unequivocally duress of the person, as established in cases like Barton and Armstrong. Now, the causal link is crystal clear. Rizal saw the video, feared for his daughter's safety, and only then delivered the excavators. As per Barton and Armstrong, the threat only needs to be a cause, not the sole cause, of entering the contract. Rizal's fear here was, undoubtedly, a causation factor. The application to this case seems straightforward, but it's worth noting that the scope of coercion in Malaysian law, particularly regarding who can be threatened, has been a point of discussion. As highlighted in the 1996 journal article entitled "Coercive Consent, the Law in Some Asian Jurisdictions" by Sheikh Muhammad Nur Alam, a plain reading of the Section 15 suggests that the victim of the threat doesn't necessarily have to be a party of the contract. The article points out that this could potentially, in quote, open the floodgates to allegations of coercion if taken to its logical extreme, that's if. However, in Rizal's case, the threat is against his immediate family member, his daughter, which is a clear and established instance that falls well within the intended scope of the law, making his claim of coercion very strong. Therefore, the contract for the sale of the excavators is voidable at Rizal's option under Section 19 of the Malaysian Contracts Act 1950 and the English common law principle of recession or duress. Okay, now that we know that contract is voidable, what is Rizal's remedy? The answer is recession. Recession means unwinding the contract, putting the parties back into the position they were before they ever had to even deal with each other. So, when a contract is rescinded, both parties are excused from the future performances. They must restore any benefit received as provided for in Sections 65 and 66 of the Malaysian Contract Act 1950. Rizal has clearly chosen to rescind. He is worried and wants out. By seeking to recover the excavators, he is exercising his rights to avoid the contract. Therefore, Razak must return the excavators, and Rizal must return the 200,000 ringgit the law seeks to restore the status quo ante. Now, there is a bit of a complication to this case. Razak has already sold the excavators to a person called Ghazali, so can Rizal actually get them back? This really depends on whether Ghazali is what the law calls a quote, bona fide purchaser for the value without notice. Now let's break down that sentence. So bona fide means, in quote, in good faith. Now for value, Ghazali paid 100,000 ringgit, so yes, he gave value. Now the crucial part, was it or without notice? Was Ghazali unaware of the vitiating factors, the duress that made Razak's title effective? The problem for Ghazali is quite twofold. He brought two Komatsu excavators for a total of 100,000 ringgit when the market price was 1 million ringgit. This is a massive 90% discount. Now, the law is concerned with procedural unfairness, not substantive unfairness in duress. However, for a third-party purchaser, a price this low should be a major red flag. It screams that something is wrong with the transaction. Because of this, a court is highly likely to impute a constructive notice to Ghazali. This legal concept means that even if he doesn't actually know about the duress, the circumstances were such that he should make inquiries. His failure to do so or his willful blindness to the suspiciously low price means he is not protected. As established in cases like Kundi and Lindsay, a person cannot pass on a good title if they themselves do not have a good title. Since Rizal can rescind the contract with Razak, Razak's title was flawed from the start. Ghazali, likely fixed with constructive notice, does not get to keep the excavators as a bona fide purchaser. So, to bring it all together for Rizal's first transaction, the contract with Razak is voidable due to the coercion or duress. Rizal can rescind the contract and is entitled to have his property returned. Ghazali is likely not a bona fide purchaser, as the gross undervalue of the sale puts him on constructive notice, meaning Rizal can recover the excavators directly from him. Furthermore, the principles we've discussed regarding third parties like Ghazali also have a powerful parallel in the doctrine of undue influence. The same journal article mentioned before by Sheikh Muhammad Nur Alam cites that very cases from our problem. Malaysian French Bank and Abdullah bin Muhammad Yusuf and organizations, noting that it was a first attempt to extend the scope of undue influence to situations where the pressure exerted by a third party who is not privy to the contract. This provides a perfect bridge to our next transaction. Therefore, under both Malaysian and English law, Rizal can avoid the contract and recover his property. Now, I will hand it over to Rup to unravel the second transaction involving Karim and the bank guarantee. Thank you.
Thank you, Daniel. Hello, everyone. Today, I want to talk about the concept of undue influence in contract law, a protection in place to stop people from being pressured into unfair agreements. To illustrate this, let's look at the second transaction involving Rizal and his solicitor Karim. Rizal had trusted Karim for a long time with his business advice. In March 2025, Karim asked Rizal to be a guarantor for a bank loan he was taking to upgrade his computer. Karim told Rizal that the bank insisted on having someone guarantee to the loan. Rizal initially felt uneasy, especially because Karim repeatedly called and texted him, pressuring him to agree. When they went to the bank, Karim even told the bank that Rizal was acting out of friendship. Despite his worries, Rizal finally signed the guarantee. Now, the bank is demanding payment from Rizal. So, what exactly is undue influence? Under Malaysian law, specifically Section 16 of the Contracts Act 1950, undue influence happens when someone in a position of power or trust uses the advantage to unfairly persuade another person to enter into a contract. English law has a similar idea. It treats undue influence as a way to invalid agreements made without true free will. There are two types of undue influence. First, there is actual undue influence, where you can prove that someone directly pressured or coerced the other person, like Karim's repeated calls and misleading assurances to Rizal. Second, there is presumed undue influence, which happens automatically in certain relationships where trust is expected, such as between a solicitor and client. If the transaction doesn't make sense on normal business grounds, the law presumes the influence was undue. Several important cases help explain this. For example, in Inch Noria and Shaikh Ali 1929, undue influence was presumed because of the vulnerable position and trust involved. The English case, Royal Bank of Scotland and Etheridge 2002, emphasizes how critical independent advice is when someone signs a guarantee to protect against undue influence. Meanwhile, Datuk Jaginder Singh and Tara Rajaratnam 1983 confirmed that solicitor-client relationships are a prime example where this presumption applies. Applying this to Rizal's case, Karim's role as solicitor gave him a clear position of power and trust. His persistent pressure combined with reassuring Rizal that he was acting out of friendship suggests undue influence. Since Rizal was uneasy and likely did not receive independent advice, he probably has good grounds to ask the court to cancel the guarantee. In conclusion, undue influence is a vital legal principle that protects people from unfair contracts signed under pressure or manipulation. Rizal's situation clearly shows both actual and presumed undue influence at work, underscoring the importance of informed consent and independent advice, especially when it comes to guarantee agreements. Thank you.
Thank you, Rup. Now let's take a deeper look at how English law specifically deals with undue influence, especially in situations involving bank guarantees like Rizal's case. English law has developed a detailed and structured approach to undue influence through key cases, particularly Barclays Bank, O'Brien in 1994 and Royal Bank of Scotland versus Etheridge No. 2 in 2002. These landmark cases focus not only on the relationship between private parties, but also on the responsibilities of banks when they accept guarantees from individuals such as Rizal. In fact, the Etheridge principles have been so influential that Malaysian courts often follow them as persuasive authority. Under English law, undue influence is divided into two categories. The first is actual undue influence, where there is direct evidence of pressure, coercion, or manipulation. This is very similar to Karim's repeated calls, messages, and reassurances to Rizal, even after Rizal had expressed discomfort. The second is presumed undue influence, which arises when there is a relationship of trust and confidence between two parties and the transaction is manifestly disadvantageous to the weaker party. A good example is the case of Elkhart versus Skinner in 1887, where a young woman who had joined a religious order gave away her property to her superior. The court held that such a relationship naturally raised a presumption of undue influence because of the trust involved and the unfairness of the transaction. Once this presumption arises, the burden shifts to the stronger party to prove that the contract was entered into freely and with independent advice. The real turning point is English law, came with Barclays Bank O'Brien. The House of Lords ruled that when a guarantor, like Rizal, agrees to secure another person's loan, especially where there is an emotional or trusting relationship, the bank is put on inquiry. This means the bank must suspect the risk of undue influence and take reasonable steps to ensure that the guarantor fully understands what they are agreeing to. This principle was later expanded in Royal Bank of Scotland versus Ettridge, number 2, which remains the leading authority today. The House of Lords made it clear that banks are always on inquiry when someone is guaranteeing another person's debts. To protect the guarantor, the bank must make sure that independent legal advice is provided. The solicitor giving this advice must personally explain the nature, the risks, and the consequences of the guarantee so the guarantor can make a fully informed decision. If the bank fails to do this, the guarantee can be set aside for undue influence. Now let's apply this to Rizal's situation. Karim was not just a friend, he was Rizal's solicitor, which means their relationship was a fiduciary, one built on trust and confidence. Karim's repeated persuasion and reassurance that there was no risk shows clear signs of influence. The bank, on the other hand, should have realized that Rizal was guaranteeing someone else's loan and therefore should have been on inquiry. Instead, the manager failed to take any precautions, even allowing Karim to speak for Rizal and not ensuring he received independent legal advice. Under the Ettridge principles, that is a serious failure, since the bank did not take the proper steps to verify that Rizal's consent was freely given. The guarantee is voidable for undue influence. This means the bank cannot enforce it against Rizal. In summary, English law recognizes that undue influence can arise both from personal relationships and from institutional negligence. Through cases like O'Brien and Ettridge, the courts have made it clear that banks must act responsibly and ensure that guarantors are properly informed before signing. In Rizal's case, because the bank failed in this duty, he should not be held liable under the guarantee. Therefore, under both English and Malaysian law, the guarantee is voidable due to undue influence. Thank you, and now I'll pass it on to Ruinesh, who will summarize and compare the overall outcomes of both transactions under the two legal systems and conclude our presentation.
Thank you. Now, over the past few minutes, we've navigated two very different but equally troubling legal battles faced by Mr. Rizal. One involved overt intimidation, the other a subtle abuse of trust. My task now is to bring all of this together to summarize his likely outcomes and to offer a final perspective on how English and Malaysian law have risen to this challenge. Now let's start with a quick recap of where Mr. Rizal stands. In the first transaction against Mr. Razak, the facts are stark. A direct threat to his daughter's safety. This is the clearest form of improper pressure. Under English law, this is duress to the person. Under Malaysian law, it falls squarely within the definition of coercion in Section 15 of the Contracts Act. Now, the conclusion is unanimous. The contractors for the excavators is voidable. Mr. Rizal can choose to rescind it, and despite the complication of the third-party purchaser, the wildly low price paid by Mr. Ghazali almost certainly means he is not protected as a bona fide purchaser. Mr. Rizal can get his machinery back. Now, in the second transaction, the pressure was different, but the vitiation of consent was just as real. Karim, as Mr. Rizal's solicitor, held a position of inherent trust and influence. His persistent pressure and the bank's failure to ensure Mr. Rizal had independent advice are fatal flaws. Now, this triggers the powerful doctrine of undue influence. Now, the presumption arises from the solicitor-client relationship and under the pivotal English case of Royal Bank of Scotland against Edridge, which is highly persuasive in Malaysia. The bank was put on inquiry. Its failure to act means the guarantee is again voidable. Mr. Rizal should not be forced to pay. So on outcomes, the message is clear and consistent. Mr. Rizal wins on both counts. But if we look closer, the journey to the same result reveals fascinating differences and similarities between the two legal systems. First, on duress and coercion, the outcome is the same, but the legal routes differ. English law on duress is broad, flexible, common law tool that has been evolved to include not just threats to the person, but also economic duress. Now, Malaysian law, with its statutory foundation, defines coercion more narrowly, more precisely, anchoring it to its acts forbidden by the Penal Code. Now, this provides certainty, but it may lack the English law's flexibility to tackle modern, non-physical forms of pressure. However, on undue influence, we see a remarkable harmonization. The core principles are almost identical. Both jurisdictions recognize the same two types, actual and presumed undue influence. And both have robustly applied these principles to third parties, especially banks. The English lead in cases like Edridge has provided a crucial blueprint for ensuring financial institutions act fairly, a blueprint that Malaysian courts have readily adopted. Now, this brings us to our final overarching point. Despite their different origins, one a creature of common law, the other a codified statute, both English and Malaysian laws are united by a fundamental equitable principle that for a contract to be binding, consent must be free, voluntary, and informed. Whether that consent is shattered by a threat to a loved one or eroded by the subtle pressure of a trusted advisor, the law will not stand idly by. Now, it draws a line to protect the vulnerable from exploitation. In the case of Mr. Rizal, that line is clear. He can rescind both transactions, recover his property, and be freed from the unjust guarantee. Now, I thank you guys for listening. That will be all for our presentation. We hope you found it informative, and thank you for your attention.